In Fremont County, Idaho, explosive allegations by the attorney for Doomsday cult mom Lori Vallow Daybell involving a possible conspiracy between the prosecutor, the LDS Church, and the Idaho Department of Health and Welfare to manipulate Lori Daybell into making incriminating statements. We have the details.
McConkey allegedly, according to this motion, called the prosecutor over Lori's criminal case, Rob Wood, and gave him the details of what Lori told him in this phone call. And once Rob Wood alerted the defense, this motion alleges that Rob Wood is minimizing what that discussion entailed.
In Santa Fe, New Mexico, the sheriff says it is wrong at this time to call the shooting by Alec Baldwin an accident. He says it's a criminal investigation. Tonight, we take a closer look at the search warrant. Is it possible the bullet was placed in the gun purposely?
Through the execution of search warrants, we have collected about 600 items of evidence. These include, but are not limited to, 3 firearms, approximately 500 rounds of ammunition, and several pieces of clothing and accessories. We believe that we have in our possession the firearm that was fired by Mr. Baldwin. This is the firearm we believe discharged the bullet.
In Brunswick, Georgia, the killing of Ahmaud Arbery murder trial, 3 men facing life in prison for chasing down Arbory in their pickup trucks and then fatally shooting him. Jury selection continues, and CourtTV cameras are inside the courtroom as we are live with the latest.
We have a real problem because the lawyers are proceeding from information that the jurors were not required to honestly recount. I mean, that's a problem, and I don't know how to fix that.
On the docket tonight in Orange County, Florida, the Suitcase murder trial. Sarah Boone accused of locking her boyfriend in a suitcase and taunting him while he dies.
Sarah.
It's my name. Don't wear it up.
I can't breathe it.
In tonight's unsolved case file in Lorain County, Ohio, Darla Kustra was walking to work one morning, but never made it there. She vanished. The only clue found by investigators, Darla's severed foot.
You take what appears to be an accident and then turn it into something I can't even imagine that somebody would remove the remains.
In Flagler County, Florida, officers stop a driver for an expired license, then find a grenade in his trunk. We have the video.
Get out of the truck for a second.
Just get out of the truck.
Get out of the truck. It looked like a possible grenade.
In San Diego, California, TikTok star is accused of using an app on his child's iPad to spy on his newly estranged wife, and then kills her and the man she was with, all in an alleged jealous rage. We take a look at the investigation during Crime Time.
I think he absolutely does deserve the death penalty for what he did. He didn't take just one innocent life, he took 2.
Plus, Alec Baldwin has retweeted a couple of articles which point the finger at his assistant director who handed him the gun. Tonight's 13th juror question: should Alec Baldwin remain silent or continue to tweet and retweet while the criminal investigation continues? Go to our Facebook pages and let us know. I'm Vinny Politan. Thanks so much for joining us. Great to have you with us here on Closing Arguments. Big night, a lot of news to get to. Doomsday cult mom Lori Vallow Daybell, explosive allegations in that case. But first, today, a verdict in the trial we've been covering here on CourtTV. If you're just coming in and you don't know, the verdict came in against Keith Johansen. Not a shocker, but dramatic nonetheless. Take a look.
In the Circuit Court 7th Judicial Circuit, in and for Flagler County, Florida, State of Florida versus Keith John Johansen, case number 2018-426 CFFA, Judge Christopher France. Verdict: Count 1 of the indictment. We, the jury, find the defendant, Keith John Johansen, as follows to count 1 of the indictment. Guilty as charged as the crime of first-degree murder. So say we all, dated at Bunnell, Flagler County, Florida, this 28th day of October, 2021, 4-person.
Would either side like the jury called?
Yes, you are.
Madam Clerk, please poll the jury.
Juror number 1, is this your true and correct verdict?
Yes, ma'am.
Juror number 2, is this your true and correct verdict?
Yes.
Juror number 3 is issued true and correct verdict.
Yes.
Juror number 4 is issued true and correct verdict.
Yes.
Juror number 5 is issued true and correct verdict.
Yes.
Juror number 6 is issued true and correct verdict.
Yes.
Juror number 7 is issued true and correct verdict.
Yes.
Juror number 8 is issued true and correct verdict.
Yes.
Juror number 9 is issued true and correct verdict. Juror number 10 is issued true and correct verdict.
Yes.
Juror number 11 is issued true and correct verdict.
Yes.
Juror number 12 is issued true and correct verdict.
Yes.
Those hands went up pretty quick. He couldn't have been shocked by it, right? I mean, he made a 911 call saying it was an accident, then gets up on the witness stand and says, yeah, I was lying back then. It was really self-defense. Jury didn't buy it. They're out a couple hours, came back guilty. Then he was sentenced to life without the possibility of parole. There you go, folks, down in Flagler County, some justice being delivered today here on Court TV. Now, I want to get to those explosive allegations. Lori Vallow Daybell and her attorney, Mark Means, in the Doomsday couple case. There they are when they were in court. Lori Vallow Daybell has been getting treatment because she's been found not competent to stand trial. So she's in the care of the Idaho Department of Health and Welfare, and they're trying to make her so she understands what's going on, trying to get better. She's getting counseling, and she's got a clinician who she works with. But now there are explosive allegations from Mark Means about a conversation that the clinician had with Lori Vallow Daybell that led to the LDS Church and ties it all together with the prosecutor, Rob Wood. Chanley Painter has more for us tonight.
Lori Vallow Daybell's attorney, Mark Means, has filed an explosive new motion detailing troubling allegations that his client, who has been deemed unfit to stand trial and is being held at a psychiatric facility, has been manipulated by her caretakers. Here's what the motion details. It says, according to her attorney, Lori is being treated by a clinician at the Idaho Department of Health and Welfare, and Lori and her clinician watched Chad Daybell's change of venue hearing together on October 5th of 2021. During that hearing, the clinician recommended that Lori contact the LDS Church headquarters legal counsel to discuss her case and possibly obtain new legal counsel. Now, the clinician reportedly provided her with the phone number and said that that would be part of Lori's treatment as a patient. The motion states that Lori would not otherwise have reached out to this legal counsel. And according to her attorney, Lori didn't want to make the call. She felt forced. Lori did call the LDS headquarters and spoke to attorney Daniel Mcmichael. She reportedly, according to this motion, told him the story, the details of her case, and allegedly made Brady violation disclosures under the guise that the church was her friend and that they were there to assist her. Now, Means insists that Lori would not have made the disclosures without this attorney, Mcmichael's, assurances that he already knew every detail of her case, and Mcmichael never disclosed any conflict of interest or that her conversation wouldn't be covered by the attorney-client privilege. Well, Mcmichael allegedly, according to this motion, called the prosecutor over Lori's criminal case, Rob Wood, and gave him the details of what Lori told him in this phone call. And once Rob Wood alerted the defense, this motion alleges that Rob Wood is minimizing what that discussion entailed. This motion is requesting the judge in the case to conduct an exhaustive, intense investigation to get to the bottom of this. It's asking for certain subpoenas. It's asking to disqualify the Idaho Department of Health and Welfare, and of course for the prosecution to hand over any Brady material or evidence gleaned from that conversation. And that's the latest in the Doomsday couple case. I'm Chanley Painter with Court TV.
There are a lot of things wrong with this. There are a lot of things wrong. I don't know if it's enough to overturn the case or get the prosecutor booted from all of it, but why is the clinician giving advice to Lori Vallow Daybell to call an attorney? And why on earth is that attorney then calling the prosecutor and talking about anything, even mentioning that Lori Vallow Daybell called him? You're an attorney. You know, someone who's charged in a criminal case calls you and you consult with them, you have a conversation. You should not be sharing that with the prosecutor or anyone else, unless Lori Vallow Daybell wants you to, but she's been deemed not competent. This is bizarre. Now, let me put up on the screen. This is what Mark Means is saying, and the biggest allegation he's making. He says it strains credulity to ignore the facts that the LDS Church/corporation and its legal counsel are possibly involved and are working with the state/prosecution/Idaho Department of Health and Welfare, at least in this instance, to manipulate defendant to be forced and manipulated into statements against her interests. These are alleged admissions that she's making to this LDS attorney. These behaviors, if true, are clearly unethical, I agree, and possibly illegal activities to undermine the defendant's constitutionally protected rights. Now, the prosecutor did respond. I want to put the response up there. And again, I have no idea if Rob Wood just got a phone call. I don't know how he reacted to it. I don't know what he heard or didn't hear. But I'm flabbergasted by the actions of the other two. Here we go. The prosecuting attorney's statement. The state will continue to focus on pursuing justice on behalf of the victims. We will address the unfounded claims by one of Ms. Daybell's defense attorneys in a court of law, not in the media. Filings of this nature are traditionally sealed and handled in confidential proceedings. Litigating such matters publicly can compromise both parties' right to a fair trial and compromise various individuals' rights to privacy. The mental health issues and investigations are not suited for the court of public opinion. That's from Lindsay Blake and Rob Wood. I disagree. I think all trials should be public. Everything should be public unless there's some major reason to seal things. It's a public trial. Anyhow, let's bring in our think tank, get some reaction to all this tonight. Joining us in the Bronx, New York, criminal defense attorney Renée Hill. In Houston, Texas, criminal defense attorney Carmen Roe. And in Atlanta, Georgia, criminal defense attorney, law professor at Emory University, and Georgia Innocence Project board member Molly Parmer. Great to see everyone tonight. I'm going to start with you tonight, Molly. Is this crazy? There's something crazy going on here.
I think it's shockingly unethical, and maybe something really nefarious and crazy is going on, okay? I mean, the fact that, so what she's doing with the Department of Health and Welfare is she's supposed to be having her competency restored. They are not supposed to be advising her on changing lawyers or assisting her in contacting some attorney who certainly did not have her best interests at heart and doesn't represent her and doesn't have confidentiality with her. I'm very suspicious of this clinician who facilitated this contact with the LDS lawyer, and I have no idea why a lawyer would then call the prosecutor. I feel very suspicious of the whole thing, and it might be a conspiracy.
Carmen?
I believe in conspiracy theories. Look, the Idaho Health Department is an arm of the state. So to suggest that they are an independent body in this situation is not real. So I'm with Molly. They have to have a hearing on this, that these allegations are unfounded. From the prosecutor is what he says, they're unfounded. I mean, we know that communication occurred with a defendant represented by counsel, outside of counsel, while in treatment, and that information was conveyed to a prosecutor in this pending case. So it's not unfounded. What we need to do is have a hearing to determine how this conversation was elicited from this defendant, who communicated the information she gave, under what circumstances, and then whether or not that information can be suppressed or should be suppressed, because her right to silence is something that is constitutional, and I think that it's been impugned in this case, no question.
Now, Renee, I don't believe that Rob Wood the prosecutor was, controlling all this. I mean, some people may believe that, and maybe there'll be evidence of it. I just don't, my instincts say no. My instincts say someone just called and we picked up the phone. But if he learned anything in that phone call, which again, he's saying he didn't, that's trouble. That is big trouble here.
It is a lot of trouble. It's quite disturbing, and I completely agree with Molly and Carmen that the conduct here is reprehensible. No one should have been speaking to Lori at all, especially an attorney who's then gleaning information and then calling the prosecution to give them that information. And when Mr. Wood received that phone call, when he realized what was being said to him, he should have ended the phone call. And now anything that comes out of that is in jeopardy here. Yeah. And it creates a problem for this case. And certainly if she is deemed to be competent at some point and goes to trial, and if there is a conviction, you better believe that all of this is going to come back up, and it's going to put any guilty verdict in jeopardy as well.
All right, let's start with the clinician. I'm thinking maybe if there's no conspiracy and there's no, she just didn't know, she or he didn't know better, right? Just didn't know, okay? They're oblivious to the law and everything. They just don't know, okay? But an attorney who gets a call from a criminal defendant, Carmen Roe, you get a call out of the blue from a criminal defendant who's been charged with murder, and they start telling things to you. It seems to me it would undermine our entire system if you could then, as an attorney having a conversation with a criminal defendant in a murder case, could then take whatever they say and just blab it straight to the prosecution.
No question, Vinny. My first call after that one would not be to the prosecutor in the case. I mean, I think McMichael, who's the lawyer in this case, who received the information and then transferred it, he is in a world of trouble. Everything about what he did was unethical, from not telling Daybell or whoever communicated for her that he was an attorney, that he had a conflict, that he didn't represent her, that she should talk with his attorney. I mean, these are all things we learn in law school. And when you don't follow them, you've committed an ethical violation and you're subject to discipline as a result. And then for him to turn around and call the prosecutor, I mean, that's a no-brainer. That is something that should and will get him in hot water.
Molly, what's the remedy here? Let's say that there was some information that was transmitted to the prosecutor. What is the remedy here? What would the court do? What do they have to do?
Depending on what that information was, if it is material to her defense, for example, if it is something that should have been protected and confidential and now the prosecutor knows, I think we need a whole different, not just a whole different prosecutor, but a whole different office. Maybe it has to be relocated. We've already changed the venue once in this trial, but we may have to start all over again, depending on what was disclosed to Mr. Wood.
Renée Hill, what if nothing is disclosed to Wood, but just to this attorney by the clinician? Then what do we do? Does the court do anything?
Well, her rights are still violated here. And so they have to have a full hearing and vet these people and find out exactly what was disclosed here, what these people know.
Let's say she makes some incriminating, she made incriminating statements to the clinician, basically admitting that she took part in these murders and knew all about it and helped plan them. If she made that admission to the clinician gives that to the LDS attorney, but the prosecutor does not get that information. It just goes to the LDS attorney. Is there any harm to Lori Vallow at that point in terms of her rights at trial?
I still think there's harm there, absolutely, because now she has made an admission to someone who she may have believed at the time had her conversations in confidence and that it wouldn't be disclosed. These people can now turn into witnesses against her, and she was in the care of a mental health facility at the time, and her attorney was not present. It seems as though they were acting as the arms of the officials here, and even if not, you know, she has been compromised, not willingly.
I just don't understand how this happens. This makes no sense to me. This is bizarre.
Makes no sense at all.
Has anything even close to this ever happened in a case that any of you have handled?
No. I've only had instances where prosecutors have done things where they potentially made themselves a witness to a case, and we've had to argue that in front of the judge as to why they should perhaps be removed because we might want to call them now as a witness. But something like this, where we have health facility, you know, suggesting that she change counsel and encouraging her to change counsel, this is insane. They're the ones who need to be evaluated at this point.
All right, we'll continue to follow this and figure out where it goes. I mean, this could be a major problem for prosecutors if, in fact, these allegations are true. When we come back, folks, we're getting ready. By the way, think tank with us the whole hour. When we come back, we're going to take you down to Brunswick, Georgia. Jury selection continuing in the case against the 3 men accused of murdering Ahmaud Arbery. And today, some more allegations by the defense against prosecutors, and a big question about the jurors, because some of them are concerned about their identities being revealed. Beautiful day in South Georgia. You're taking a look at the Glynn County Courthouse in Brunswick. This is the site of what is going to be a huge trial, jury selection taking place. And once they get that jury in place, things will start. CourtTV cameras inside, gavel-to-gavel coverage. This is the trial involving the murder of Ahmaud Arbery. Ahmaud Arbery, young guy from South Georgia, down in Brunswick, was out for a run, running through a neighborhood he had run through before. Satilla Shores, was followed by 3 men in 2 pickup trucks. They pursued him, and then eventually Travis Mcmichael, who had a shotgun in his hand, shot and killed Arbory. His father, Gregory, was in the back of the pickup truck on the phone with police at the time, while William Roddy Bryant was in the trailing pickup truck with his cell phone recording the whole thing on video. Let's bring in the CourtTV legal correspondent Julie Janae is joining us live from Brunswick tonight. What is the latest in jury selection?
Vinny, the latest is we have now 47 of the 64 potential jurors that are qualified, that we need to get to the 64 that the court would like to have before those peremptory strikes today. It was a long day, not only for the potential jurors and the attorneys and court staff, everyone involved inside of that courthouse, but also I watched as Ahmaud Arbery's mother, Wanda Cooper Jones, walked out of the courthouse today very late, and you could tell it's just a tiring process for many of the people involved. Here's a look at the scorecard for that pool of 20 who were inside of the courtroom today. Actually, it was only 19 that showed up. 4 of them said that they knew Ahmaud Arbery personally. 3 knew his parents, Wanda Cooper Jones and Marcus Arbory. 2 said they know the Mcmichaels. Another 2 said that they knew Kevin Goff. And there were also 7 who answered questions about law enforcement. They raised their hand to say they'd had a good experience with law enforcement. 12 agreed that people of color are treated differently by the criminal justice system, and 4 were concerned about their safety or career if they were chosen to serve on this jury. I had the opportunity to be inside of what is typically a more secret individual voir dire process where only a few members of the media are allowed inside. There are tense moments. There are some jovial moments when these potential jurors come in, but it can be very daunting for them to come in and see all of these attorneys around the courtroom, just circling them and tossing these questions at them one by one.
It is. You're kind of put in the spotlights. They're trying to pick you apart, figure out who you are. There were some allegations today, or some issues involving a juror and social media, Brady violation. What's going on down there?
This was a point of contention at the middle of the day. There was a break in the afternoon, and when we came back from the break, Kevin Goff, the attorney for William Roddy, put a motion on the record with the judge having to do with social media. So I want to start first with juror number 199, because that's really what tipped all of this off. She's a black woman in her 50s or 60s, appeared to be on the questionnaire about Ahmaud Arbery. She said they hunted him down and killed him like an animal. But she did say that she could be a fair and impartial juror in this case. She said nothing about the posts that she's seen on social media would keep her from being fair. Then Jason Sheffield, the attorney for Travis Mcmichael, he raised the issue of some postings that he said were on social media. She initially said she didn't remember these, but he asked her if she posted "Happy Birthday, Ahmaud" on the date that the defendants were arrested. When she was shown those, she agreed that she did. She also posted "Now it's time for justice," referring to this case. And through that questioning, she also revealed that her Facebook profile name is actually different now than it was when she filled out the questionnaire. She says she does that often, really every 2 or 3 months. It's just something she likes to do. But that spawned a conversation about whether or not these potential jurors are even asked if the questions that they answered are still accurate while they are answering these questions, because remember, they filled this out at least a month ago and turned it in to the court. So here's some of that argument from Kevin Goff.
I'm making a motion orally under the 5th, 6th, and 14th Amendments of the United States Constitution, under the parallel provisions of the Georgia Constitution, and pursuant to Brady v. Maryland and its progeny, because I think the examination of the last juror by counsel made it abundantly clear that there is a tremendous disparity of resources here. The defendants are laboring under limited resources, under the best of circumstances, particularly when it comes to the social media stuff, which is relatively new. I mean, I've never had a jury trial before where social media was such a significant, it's one thing in divorce court. That's all easy to follow. This is very different. I believe, I would assume that the state has amassed substantial dossiers on all of the jurors. When I was a prosecutor, we certainly got the best that we could get. And obviously from the questions and responses of the jurors, the state has social media information, and we suspect a lot more information. There is such a disparity in this 21st century digital age, Your Honor, with all this online and social media, that it is impossible, even for the best defended defendants, to keep up with all of that. And if the state has exculpatory information from social media or other places with respect to, it's not exculpatory, it is with respect to the bias and prejudice or impartiality of jurors, if they have that information, if they know that a juror isn't being truthful on social media or has said things that would suggest that they are biased or partial against any of the defendants in a case, then my contention is constitutionally, the state is required either to share that information with the defense or, in doubtful cases, that they would submit that social media to the court for an in-camera inspection. And if, in fact, the court finds social media or other material in possession of the state that would be material to the defense in selecting a jury, then we're entitled to have it. To say that you have a right to a trial by jury, to say that you have a right to voir dire the jurors, but withhold the information that the state is peculiarly situated to have, creates such a fundamental imbalance and unfairness that it would essentially deprive defendants of a fair trial before it even begins. Now, if I had a case to cite, Your Honor, I'd be happy to do it. And I know this is a shock to Your Honor, but I don't. I guess someone else tonight will have another homework project. But I just think the vast disparity of resources between the state of Georgia, and I'm not picking on the Cobb County DA, but there's a lot of other people behind them, including the Georgia Bureau of Investigation. The state is the state. But given that vast disparity of resources, there's no way that lawyers sitting up at 3 o'clock in the morning looking on Facebook or Pinterest or Twitter or Instagram are ever going to be able to keep up with the resources that the state can and has amassed in this matter.
So many creative arguments from Kevin Goff. So he's asking for the prosecution to turn over any social media information that they have about these potential jurors. He also wants to know that these potential jurors are going to be asked or told that their questionnaires are under oath, and with penalty of perjury, the judge said they can start asking these jurors if anything has changed, but he did not rule on whether or not there is a Brady violation.
Okay. Was 199 bounced, or is 199 still in play?
199 was actually qualified, so she will be returning to be part of that 64.
Wow. Okay. This jury, are they going to be anonymous?
Excellent question. It's a question that came up today, really when a juror was concerned about their safety. And here's a look at juror number 181 and what she said. The prosecutor tried to assure her that she would be protected. And she said if selected, she would be concerned for her safety, would be concerned about her ability to listen to the case because she values her life and her property. And if her identity is protected during the trial, her concerns would be alleviated. And when the prosecutor tried to tell her that they would be doing what they can to protect her, she was asked to leave the courtroom momentarily. The judge did say that this is not officially an anonymous jury like we see in other cases. These jurors' names are still on the record, not where the media can see them, but the court staff knows them, the people involved, the parties, everyone knows their names. And it's not something that they can control sometimes about people knowing who they might be. So the defense wanted to make sure she knew that this was not officially an anonymous jury, and the court can't guarantee that no one will find out who she is, especially after a verdict in this case.
All right, Julie Janae in Brunswick. Let's get some reaction tonight from our think tank, Renée Hill, Carmen Roe, Molly Parmer, still with us. All right, Molly, juror 199, did she sound fair and impartial?
You know, I think that's
the
a classic.
Ahmaud Arbery birthday post, and they hunted him down like an animal.
Yeah, see, here's the issue. What actually happens during this phase of jury selection is that jurors are asked, their feelings and their sense of the case, but then there's this follow-up where the jurors are rehabilitated. And what happens then is that the judge or whoever is asking the question says, okay, but in light of all of that, juror 199, do you still think you could set that aside, listen to the evidence and the testimony presented in this case, and render a fair and impartial verdict based on that evidence and testimony? And it's real easy for people to say, you know what, yes, I can, despite my Facebook posts, which, they didn't know about those at the time, but it's real easy to qualify people so long as they're rehabilitated. But is that genuine? Is that true? Is that real in the heart of juror 199? I am doubtful that it is, that she is fair and impartial. But all she has to say are those magic words. And guess what? She's part of the pool.
All right, Carmen Roe, should the prosecution be handing over all their research on social media about these jurors?
I love this lawyer. I love how creative he is. Without a case, with a case. I mean, I've never heard of such a thing. No, I don't think so. Jurors need to be qualified to serve. And if the state had information that they were not qualified to serve, I think that would serve their interest to turn it over, because it could result in a reversal on appeal. Other than that, I don't think they have to do the homework for defense counsel, but I love that he's being creative enough to see if they'll do it for him. But I can't imagine that's happening in real time. But again, I love the arguments.
Renée Hill, how about the anonymity? This is becoming much more common in these high-profile cases. Do you think this jury should remain anonymous, and that would help them be able to be fair and impartial and render the verdict based just on the evidence and not worry about anyone coming after him?
I mean, if you start to get a lot of jurors indicating that they are fearful to sit on the case, if they are not anonymous, then that's something that the court will certainly have to consider. And it might be helpful in the same way that you would consider whether or not the jury should be sequestered, so that they can focus totally on the case and not be concerned about anything else happening on the outside. It's something that they can certainly take into consideration, and it might be helpful for this jury.
There was a jury that was anonymous. That was the jury in the trial of Derek Chauvin, the man who murdered George Floyd. But some of them are no longer anonymous. They were on with Don Lemon. Let's take a look.
This was about, obviously the death of a man, but I'm sure you knew the whole racial aspect of it. You're very diverse, and nobody was afraid to share their feelings on that?
Not at all. Race wasn't even ever mentioned in the 3.5 weeks that we were in that courtroom, and it was never mentioned during deliberations, I don't believe.
I mean, I think we got here because of systemic racism within the system, right? Because of what's been going on. That's how we got to a courtroom in the first place. But when it came down to all three verdicts, it was based on the evidence and the facts, 100%.
Okay, that case, not about race. This case, Ahmaud Arbery, is it about race? What do you think, Renée?
It's certainly about race. When you look at the fact that Ahmaud was a black man running through a white neighborhood, you look at how he was treated by the defendants in this case, you look at the words that were spoken, even after he was shot and dying on the ground, it's absolutely about race.
All right, but
100%.
Carmen, do you think the lawyers will be talking about race to this jury?
If they don't, then they're making a mistake. I mean, they need to talk about race. And other commentators have said it, but if I was running down the street in that neighborhood and I stopped by an abandoned location, I don't think I would be chased down and killed. And so race is very much an issue. And the demographics in that area, I think, tell us that it is an issue and it has to be discussed in that trial.
Will both sides discuss it, Molly?
Yeah, I think both sides will. Look, this is my home state, man, and this is the Deep South. And racism and all of its vestiges are alive and well in the Deep South. And both sides are going to talk about it for a number of reasons, because don't forget, the defense is going to rely on this Civil War era citizens arrest law, right? And that license plate that now we're fighting about, are we going to show the Confederate flag or not? That's actually the Georgia's former state flag. These are all issues that are going to come up and be discussed by both sides throughout this trial.
All right, think tank staying with us, still ahead. On the docket tonight in Orange County, Florida, the suitcase murder trial. Sarah Boone accused of locking her boyfriend in a suitcase and taunting him while he dies. Plus, Alec Baldwin has retweeted a couple of articles which point the finger at his assistant director who handed him the gun. Tonight's 13th juror question: should Alec Baldwin remain silent or continue to tweet and retweet while the criminal investigation continues? Go to our Facebook pages and tell us what you think. On the docket tonight, the suitcase murder trial. Here's the story of Sarah Boone.
911, what is the location of your emergency?
It's Monday, February 24th. There's a crisis at the home of Sarah Boone, prompting her to call 911.
Is this a police or medical? My boyfriend is dead. Okay, send the line for the fire department. Do not hang up.
The fire department takes over the call, and for the next few minutes, officials are obtaining critical details about what happened.
Now, tell me exactly what happened there.
My boyfriend and I were playing last night, and I put him in a suitcase and we were playing, and like kind of hide and seek kind of thing. So I fell asleep, and I woke up, and he was dead in the suitcase, so I don't know what happened.
Okay, is he hanging from somewhere or what, ma'am?
No, I pulled him out of the suitcase. I tried giving him CPR.
Fire and rescue instruct Boone on how to give chest compressions.
Just keep on pumping. That's all you need to do for me. Keep on pumping his chest for me. I don't need you to stop and talk or anything. I just want you to count out loud for me, okay?
31, 32. Please hurry.
Okay, man, they're getting there as fast as they can, okay?
He's stiff and he's purple.
EMS arrived within minutes and advised Boone that her boyfriend, Jorge Torres, had been down too long and there was nothing more they could do. Boone explained she and Torres were drinking the night before and thought it would be funny if he got inside of a suitcase for a game of hide and seek. The next day, deputies returned and arrested Boone and charged her with second-degree murder in Torres's death. Boone's story about a childhood game gone awry unraveled when investigators say they found video on her cell phone showing Boone taunting and laughing at Torres while he was struggling to get out of the suitcase. Police say he was yelling he couldn't breathe and asking Boone for help. According to police, Boone was captured on video saying, "That's what I feel like when you cheat on me." When confronted with the video, officers say she told them she didn't remember those moments. But to investigators, those moments add up to motive for second-degree murder. And this case is happening, folks. We got a trial date of December 13th, the final pretrial hearing on November 30th. But December 13th, Florida versus Sarah Boone. When we come back, it's time to hear from you, the 13th juror. Alec Baldwin not remaining silent on Twitter. He did tweet out initially to supporting the family. Now he's retweeted some articles that are pointing the finger at the assistant director. And I'm wondering, should he remain silent? Your verdict next.
Sheriff, as the man who pulled the trigger and as a producer on the movie, does Alec Baldwin himself face the potential of criminal charges? And if the DA could perhaps follow up with that as well.
That may be a question better answered by the district attorney.
All options are on the table at this point. I'm not commenting on charges, whether they will be filed or not, or on whom. So the answer is we cannot answer that question yet until we complete a more thorough investigation.
But there is the potential for Alec Baldwin himself to face charges because you have not ruled them out.
No one has been ruled out at this point.
So it's a criminal investigation. No one's been ruled out. And Alec Baldwin, while this is happening, he initially tweeted support of the family. We talked about that. But subsequently, he's retweeted a couple of articles involving the investigation here. One from the New York Times, which basically says the gun handed to Alec Baldwin was not thoroughly checked, and talks about Dave Halls, the assistant director, said that he should have inspected each round in the chamber. A second one from Apple News, where Alec Baldwin was told the prop gun was safe before the fatal shooting. So here he is retweeting articles that point the finger at the assistant director and point it away from him, Alec Baldwin. I posted about this on social media asking you, do you think he should remain silent or continue tweeting and retweeting about all of this? And we begin with our 13th juror. Comment of the day from Scott, who says he should remain silent and let his attorney deal with this. This is a terrible accident. I'm sure he feels terrible about what happened and struggles with it every day. As they say, anything said can and will be used against him. He shouldn't be tweeting anything. Carmen Roe, your thoughts about Alec Baldwin going on Twitter, whether he's tweeting something or retweeting something?
I, as any criminal defense attorney would say, he needs to be quiet. But in this case, to me, it's obnoxious that he's tweeting. Look, 4 out of 5 people were supposed to check this gun. He was one of those people. So just like I tell every client, you can't talk your way out of this by tweeting or retweeting or whatever. And that's all he seems to be doing in this terrible tragedy, is looking to point the finger. Well, let me say this about that. He's one of the people that had a responsibility here, which is why he's still on the chopping block for charges.
Elaine tonight, he's not talking. He is retweeting what others say. Nothing can be used against him for all the geniuses commenting. But he should not retweet because it is not nice for the victims and the families. Molly Parmer, let me ask you this. There's also been conversations about that everyone's giving statements voluntarily. Everyone's cooperating with police in this criminal investigation. Would you advise him to continue to cooperate with police in this criminal investigation?
You know, I think sometimes it is a good strategy alongside your lawyer to make a statement or potentially assist in a cooperation type of posture. But I think he said plenty. And at this point, no, there's no need to go above and beyond. And I'm sorry, Elaine, but those tweets can and will be used against him. It's anything you say, whether it's on social media or in a statement to an investigator, anything you say. So well, please don't tweet.
Technically, it's a retweet. So he's just kind of like forwarding something that someone else said. But retweets have been used against other people in the court of public opinion, at least. Noel tonight, it was his responsibility to recheck the weapon once it was handed to him. He should also have never pointed it at someone or had his finger on the trigger. Retweeting everything is him trying to point people to look in another direction and forget about him. Renée Hill, is he being too proactive, too defensive? Should he just remain silent? What do you think, Alec Baldwin? Because he's in a different position than anyone else in all of this. Number one, he's the shooter. Number two, he's Alec Baldwin.
And the bottom line here, though, is that this is an active criminal investigation, and he is still a subject of this investigation. Therefore, he should not be speaking. He should not be tweeting. He should not be retweeting. He's not out of this. So anything that he says or does is going to be looked at. And if he is charged in this case, can be used against him, just like Molly just said. Anything that he says or does can be used against him if he becomes a defendant in this case. So he should be listening to his attorneys. And I'm sure his attorneys and PR people are telling him, stop it.
Well, sometimes PR people and attorneys see things differently, but in this case, I'm not. Something struck me about the retweet. It just didn't seem right at the time. I don't know. I might be wrong. Yeah. Amanda tonight, if he's commenting at all, it should be in support of the victims and their families. He did do that. That was his tweet. These are retweets that don't go in that direction, go in a completely different direction. But Carmen Roe, how about the initial tweet in support of the family? Does that affect the criminal case at all? Is that an admission of anything here?
Of course it is. Anything he puts in writing, especially his words, his actions, as Renée said, retweeting, everything is part of an investigation, and he is under a microscope, and he should never, ever forget that. Anytime there's charges pending, anytime there's an investigation, you're under a microscope, and every single thing you do matters.
All right. And the last one, Elizabeth, he should tweet anything he thinks or feels, because at the end of the day, his life has changed forever, and I can't even imagine how he must be feeling. Knowing his history of tweeting, that could be very, very dangerous in these circumstances. Molly Parmer, Carmen Roe, Renée Hill, thank you so much. Great to see you tonight. We'll see you again real soon. All right, folks, when we come back, we're going to continue to take a look at this investigation and ask the question, could this have been sabotage? Don't go away. In Santa Fe, New Mexico, the sheriff says it is wrong at this time to call the shooting by Alec Baldwin an accident. He says it's a criminal investigation. Tonight, we take a closer look at the search warrant. Is it possible the bullet was placed in the gun purposely?
Through the execution of search warrants, we have collected about 600 items of evidence. These include, but are not limited to, 3 firearms, approximately 500 rounds of ammunition, and several pieces of clothing.